Doesn't vibe with the soup.
It feels weird not having it though.
Yeah. It's like me if I don't wear earrings or without my glasses because it's like it's just. I'm Rachel. I'm just really good with faces,
Okay.
which lends to me being really weird. So I'm sorry.
I like a lot better than last one.
That's how my contrast professor was in the first day.
Larson didn't do that. He was just on a whole different level and it didn't really translate. Ridiculous.
David, when Alex gets here, will you tell us? Yeah, well, I met her last semester. She's awesome. Yes, she will be very expensive at the end of the semester and will have a English exclusive who says every season she will test one.
Shout out. Someone at the
Great.
How you doing? They said that apparently this year they found some. Yeah, because they're like don't want to do that. Still not in their mouth. Yeah. Is it fun?
Yeah, like
That's better than most people.
yeah, I mean it was just very I just feel like there wasn't much guidance on what we were supposed to do. And like a lot of the guidance was very negative. And so I was like, well, exactly my argument right now. That made it a bit harder, but I kind of here's like an address things like very quickly. So. Yeah.
I had to like stick with the word limit.
Yeah.
Just like citation.
Yeah.
Wow.
I
had exactly 4,000.
Oh, really?
You remember?
Oh.
He gave me a card for the same person.
It's like
As soon as I said that. No, I
I'm like sweating right now. Literally one would be.
You and Jesse did it together.
So,
It's hard to take a chance to.
No, we're not going to argue that.
No, I'm saying having a field trip.
Stay private. Did you want it?
Yeah.
It's like, I hope we should.
And you shouldn't have granted.
We're not going to move it. We're going to leave it. Do I have to call it, or am I picking it up?
It literally picks up and calls for you.
So it's like the bank alarm, like if someone's robbing the bank, you hit the button.
Essentially. Yeah. But that's like if the microphone or something else is going.
Got it.
Yeah.
Okay.
And then the first advocate, like I can pick up for their 5 minutes. It's just like that, like I said.
Yeah.
Full time and whenever you want that.
Like 1 minute, yeah.
Okay. So as long as you got the time.
No, that's easy. Thank you. That's a great tutorial. Really appreciate it.
Oh, hello, Amy.
I'm here too, Andy.
And
Don't
Shay.
prompt a hello.
I have to grab another one.
Like music. Majority of it.
In your rebuttal, you want the yellow light to pop on.
Well dressed Evan is, my goodness. He looks like he's ready for a post.
Oh, okay. Well, if you find it,
Nice welcome, buddy. That guy goes so hardcore.
Yeah, no, I gotta say that's.
Remembering that
Actually,
I was wondering if I was gonna have to write a whole bunch of notes and, you know.
no, those are just there, like all else fails.
when we got back
Lots of ways.
Right now I have no time.
Oh, I thought she meant because we're like too close. You don't want headphones? Dan?
Are they?
That's me. I argued for like an hour. I walked. Sound one.
That's how I keep it.
How bad?
Yo, you hear that?
How bad were we?
And
I haven't put that since there. I think it's 7 my own but now I have to I don't know.
It's a little harder.
7, yeah.
I imagine the smaller the belly.
And then after
Okay, I've got to go.
You're not.
I understand.
stop it here.
I
Staked it out over here.
I wanted to go to Harlem.
Sorry, I was talking
They weren't good at showing up quick.
organization, the agency that
Isn't that probably
reviews and grants licenses in Miami. The guy who
I was gonna say, it looks like
things are happening. How long does that take? The undergrad newspaper. Sorry. But I want their support to turn into advocacy.
It's on my side. I got it.
Yeah, that's exactly what I didn't want to bother you on track. Okay, great. Where are you? You're worried, but you're like just never
We have these. But I don't see why. Oh yeah, I was out swimming in the dark last night. For Georgia.
I was thinking about it.
I'm like Kyle.
What? I've heard it. I couldn't tell you. It's kind of like
Alright, you're at
Very excited.
and then have more. But I talked to the monitor. No, I said
Progressive.
I can accurately say
When he said that, I was like, okay, remember? I was trying to talk to him.
I thought that was
Lisa, where's my president? There you are. Yes, ma'am. Come on, through. She just went out.
somebody ran after.
Good afternoon, everyone. Welcome on behalf of the Military Law Society and the National Security Law Association to the Army Court of argument today involving the actions of Staff Sergeant Jason Lopez and the parties who authorized the search of his living quarters. This is a military court, an Article I court, whose laws and procedures flow from rules codified by Congress. And the Constitution imbues Congress to make the rules that govern the land and naval forces. And that's why we are here today, because Congress did codify those rules, and they codified them in the Uniform Code of Military Justice. You're going to hear today about articles and about the code. That's the Uniform Code of Military Justice. And if you have any interest in military law, any interest in the code, then you should enroll for Dean Skank's military justice course in the fall. So at issue here today is a search. Now, how many of you have taken criminal procedure? Anybody? Oh, yeah. I got it. So, you will. But at issue here is whether a commander had the authority to issue a warrant, whether that warrant was based on probable cause, and if there was no probable cause, whether an exception applied. So Captains Jones and Turner have been working very hard to write briefs and prepare these arguments, and they will argue ardently for their clients. So from all of us here at GW, MLS, and the National Security Law Association, we hope that you enjoy these arguments today. Thank you very much.
Hi folks, I'm Max Squires. It's my honor to be the Clerk of Court and Judicial Advisor to the Army Court of Criminal Appeals, and I've been coming here to these outreach arguments since before most of you were born, I'm pretty sure. Okay. It's a great pleasure on behalf of Brigadier General Joe Berger, our Chief Judge, who was called away to Europe to drink good beer and not American swill. No, he would have loved to have been here today. But unfortunately, duty said otherwise. A couple of points I want to make with you, if it's okay. First of all, there's no photography to be taken once the judges enter the room. Until the judges enter the room, you may take all the pictures that you want to. If you've got a cell phone or a smartphone or whatever it is, I have a Cellosaurus as my soccer team refers to it. But they turn it off. Whatever it is, turn it off. Don't text. I can hear you texting. I'm 70 years old, but I got good ears, okay? Don't do any of that sort of stuff. After the argument today, we'll have a question and answer session. The question and answer session will end at 1:30, regardless of how long these folks right here argue, because we know that you've got to get back to class at 1:30. Rules of the road on the question and answer session. You may not ask any questions about the case that you have just heard, because obviously it's under advisement and no opinion has been written. And I would appreciate it greatly if you would not ask any questions about any of the big cases that we have pending in front of us. So if you know names like Hassan or Manning or Bergdahl or things of that nature, don't ask any questions, because one, they're not going to answer it, and two, I might have to put my hand over your mouth. Okay, that's not good. I'll wash it out with soap. All right. Nothing that we have pending can we talk about. Other than that, you can ask any questions that you want to, and you'll get great answers, both from the council here, the young folks, or the old folks that are sitting up on the bench. Okay? And if you want to know something about the Iron Age, I can probably answer that for you. All right. Are you ready, good sir?
Yes, sir.
All right. Well, let me go ahead here and get these wonderful judges, and you guys get ready to stand up.
All rise. The Honorable United States Army Court of Criminal Appeals is now open and in session. Senior Judge Wolf presiding. All persons having business with this honorable court are admonished to draw near and give their attention. God save the United States and this honorable court.
Please be seated.
right, good morning, everybody. This morning we're going to hear an oral argument in the case of United States versus Staff Sergeant Jason Lopez. Counsel for appellant, ready to proceed?
Yes, sir.
And government.
Yes, Your Honor.
All right. And Captain Turner, how would you like to split your time today?
25 and 5, Your Honor.
Great. Proceed when ready.
Yes, sir. Senior Judge Wolf, members of the court, may it please the court. I am Captain Augustus Turner, and along with co-counsel Captain Heather Martin, we are proud to represent the appellant in this case, Staff Sergeant Jason Lopez. In this case, a commander authorized the search of a private home. Now, the president empowers him to do so under the military rules of evidence if he controls the home in question. In this case, he did not.
Well, counsel, let me stop you right there. There was some question in the briefing about the ownership of Porter Village.
Yes, sir.
I think you indicated that Porter Village was owned and operated by Villages at Benning. Is that
Yes,
right? Sir. But I'm looking at specifically Joint Appendix page 371 that says that Porter Village is owned in fee simple by the United States of America.
Yes, sir.
So which is it?
It's owned and operated by Porter Village. Now,
well, now let me hone you in on the word owned. Porter Village is a private entity, correct?
yes.
Okay, so...
Well, it's the name of the neighborhood. Yes, sir.
Okay. Oh, excuse me. Owned and operated by Villages at Benning.
Yes, sir.
So Villages at Benning is a private entity.
Yes, sir.
So how do you reconcile saying that Villages at Benning owns it with Joint Appendix 371? I don't understand how it could be both.
So I'll explain. Both are technically true. It's the chronology and also the facts that were omitted in the suppression hearing by the government and the military judges, what gets to the heart of the error, sir. First, there was a time in 1993, as shown in that lease, where the government purchased, acquired, and owned this neighborhood in Delonga, Georgia, Porter Village, this neighborhood where appellant lived. However, what's not accounted for, again, by the government who bore the burden to show that the commander controlled that house at the time of the search, was that in 2006 it was privatized, which meant it was turned over to private control and ownership. This was a fact that was noted by the chain of command when discussing the search. It's in the search authorization itself, and it's noted by the military judge on page 386 of the Joint Appendix.
What does that mean to turn? I guess what does that mean to turn it over to? I guess here's maybe a way to simplify my question.
Yes, sir.
If I wanted to buy the house that Sergeant Lopez was living in, could I do it? Could I buy it from Porter Village, or does the United States still own it?
What's clear from the record, sir, is that one, it was privatized. We know that. We know that precluded the commander's control. The ownership aside, it precluded his control. Now, if you could buy Porter Village, given the federal case law, what federal courts have noted about the privatization of Porter Village and Villages of Benning, they owned it, so you would have to buy it from Villages of Benning.
So Villages of Benning wanted to sell me the house, they could do it.
That's correct, sir.
So Captain Turner, Battle Park Homes on Fort Benning is also privatized. Lots of housing areas at installations across the U.S. are privatized. Does that mean they can go in there? I can go in there and sell or buy those quarters? Does the government not have control over those that are actually on installations?
Well, and that's a great point, Your Honor. So the distinction between homes like Battle Park Homes, which as you noted, which is within Fort Benning, and Porter Village it's within the confines of Fort Benning. It's on the installation, even MCO 190-.
But if they don't own it, is there their determination that's within their jurisdiction? Is that not just ultra virus? I mean, how can you say that you've got control and ownership over something that, under your theory, the government doesn't even own?
Well, I think, again, this goes to the point that the government bore the burden to show how a commander could control a privatized house that was completely, unlike Battle Park Homes, was outside of the gate.
Well, you're talking about the government burden. We'll get to that in a second. The government introduced a deed that the government purchased in fee simple. That means to me their burden that they own it. If you're saying there's other evidence that they didn't introduce that would help you, the government's not obligated to introduce evidence that helps you. They introduced evidence that said the government purchased the property.
Correct, sir. They did introduce evidence that in 1993 the government purchased it. However, what was not accounted for, as the defense raised,
you're pointing to stuff not in the record.
Well, the defense did raise in the record in their motion to suppress that the privatization of Porter Village precluded control under MR.
Okay, but did they introduce evidence that supports it?
It wasn't the defense's burden. The government had the burden to show.
The government introduced a deed. All right, so the evidence in front of the court is the government owns the property. If that is incorrect, the appellant needs to explain that. The government's met its burden to show ownership when they introduce a deed.
Well, ownership is separate from control, Your Honor. The question.
Well, you said ownership. If you want to give up ownership and we can move to control, that's fine. But you said in your brief ownership, and you've maintained the position here. Does the United States own Porter Village?
They do not, Your Honor.
Okay.
As shown by the Middle District of Georgia in 2015.
All right, so let's move on to control.
Yes, sir.
Which I think is definitely your stronger argument. The U.S. Army and military organizations everywhere lease all kinds of property on military bases.
Yes, sir.
Fort Belvoir, which we are all familiar with, has an Arby's.
That's right, sir.
Okay. There's presumably some type of contractual leasehold relationship with Arby's that encourages them to actually build the Arby's and create the signage with enough assurances that they would be able to own and operate for a certain period of time. Can the garrison commander at Fort Belvoir search the Arby's if there's evidence of a crime that occurred at Arby's?
I'm not sure, Your Honor. I know that the Arby's on Fort Belvoir is within the gates of Fort Belvoir, which would give him control of everything within the gate. So he probably could, assuming we're talking about an Arby's that's on a structure that's within his control.
You know the one I'm talking about. They got the meats.
So they do have the meats, sir. Speaking to the erroneous conclusion of the law, sir, the president and the CAF require that the commander control the House. The CAF is rejected in 1993. Actually, the year Porter Village was bought by the government, the CAF rejected a government argument and a military judge's conclusion.
Now, real quick, you're going to get into Chapel, but before we get into that, is your argument that this commander has no control or the U.S. government has no control over Porter Village? Or both?
There's a distinction. So the commander does not control Porter Village. No one leases a home from the garrison. They don't. When there's a problem with something at the village, when there's a problem at Porter Village, they go to their landlord, Villages of Benning, not the garrison. Now, the FTCA cases on JA-13 that we've cited, what those help to illustrate to this court is that the government not only, if there is a business relationship between Villages of Benning and the government to effectuate the privatization, the government has a legal interest not to control these companies so as to avoid liability.
Certainly for torts liability and all that, but how about for law enforcement and security purposes? There is a memorandum of agreement with the state of Georgia. Is that completely subsumed by the privatization of Porter Village? Is that your theory?
We do, Your Honor, but to the extent that the MOA survives the privatization, it still does not give. One, the plain language of the MOA mentions nothing about a garrison commander's control, ownership.
Well, what is concurrent jurisdiction? If the United States Army has concurrent jurisdiction over Porter Village, and that's the agreement signed at a very high level.
Yes, sir.
What does that mean, if not jurisdiction over criminal offenses?
So, jurisdiction again is different from control. The president requires control of the House. Jurisdiction. A U.S. attorney has jurisdiction over a federal bank. He does not control the bank. A commander.
Haven't garrison commanders in privatized housing barred registered sex offenders from living in Army privatized housing, and that's been upheld in federal district court as a proper control by a garrison commander?
I'm sure that I haven't read those cases, but I would acknowledge that that's probably been the case. But those houses, I'm almost certain, have also been within the gates within the gate
so
too,
for you,
as well.
It's this magical thing that Porter Village is not actually inside of Camp Merrill. That's the key to your argument, because the privatized housing on Fort Benning, Georgia, you say no problem with that. That's
we acknowledge that within a gate, the entire purpose of going on the gate is to come under military control. However, outside of that gate, combined with the private nature of this home, which is essentially in a neighborhood, in a civilian town that relies on civilian services primarily, there is no control. And back to Judge Hagler's question, you had asked about the MOA and jurisdiction and the law enforcement responsibility. I'd like to note one, to the extent it survives the privatization, let's just assume it does, Your Honor. The problem is, first, the plain language of this MOA doesn't even address what a commander can do. It doesn't even mention a garrison commander. Second, the CAF has already rejected the idea advanced at trial that responsibilities, law enforcement responsibilities from a Naval Support Activity Commander, which is the equivalent of a garrison commander, it amounts to control under MRE 315D.
We talk about surviving the privatization. When did you say the privatization took place?
In 2006.
Okay, so it was 2009 is when the governor of Georgia signed. So how does it? It seems like the later in time would. I don't see why it would need to survive the privatization if the MOA took effect at the highest level. We're talking Secretary of the Army and Governor of Georgia signing this and goes into effect in 2009. So how does that?
It wouldn't be the first time one arm of the government didn't know what the other arm was doing, where one arm gives jurisdiction under the presumption that it owns something, or it did. It bought this land back in 1993. But again, the memorandum also doesn't discuss anything about the privatization. Just as the government didn't at trial, and just as the military judge didn't in his findings of fact.
You seem to be relying on the fact of what the government didn't show at trial.
Yes, sir.
And the government's obligation at a suppression motion is to respond to the basis to suppress that are raised by the defense. So could you please point me to the part in the defense motion to suppress where the defense asserts that the garrison commander does not control Porter Village, and therefore the search authorization is illegal?
On JA 311 and 312, and also on JA 306. Also on JA 306, they simply summarize their argument in their four bases, and basis 4 is the authority to grant the search, and they go into detail on that on JA 311 and 12, where they argue that this is privatized housing, and under Chappelle and 315D1. This precludes his ability to authorize a search. So while I don't see the exact word of control, but Chappelle, 315D11, or 315D1, that is control. The president requires the word control. The operative word here, gentlemen, is control, not ownership, not jurisdiction, not responsibility. Again, if we're talking about responsibility or jurisdiction, there may be more oxygen here for this argument to breathe for the government and for the military judge's conclusion of responsibility. But again, that's not the plain language of MRE 315D1. The CAF has rejected in 1993 the idea that a garrison responsibility rises to the level of command and control. In fact, in Chappelle, they addressed the two arguments advanced in this case.
I think you put way too much weight on Chappelle, counsel. That was an apartment out in Italy. It had no. I mean, it was an Italian landlord. There was no similar MOU that there is here. I mean, how are you saying that? I mean, it seems like it's distinguishable in so many different ways.
I'm sorry. Go ahead.
No, I'm not really seeing the analogy there.
We acknowledge the distinction that obviously that Chappelle was in Italy and this case is in Georgia.
Well, it's not just it's in Italy, but there was no similar MOU with Italy, for example, for that area where Chappelle was living.
Well, the MOU only establishes concurrent jurisdiction, and again, the plan is not even in the MOA, but it's inferred from the MOA that the garrison commander has a responsibility arising from this MOA. It's not even in the MOA itself. We're all inferring that from what's in there. So again, that's a responsibility. A responsibility is where Chappelle controls this case. It kills the reliance of responsibility. It says if that's all you have, that's not enough.
What's your interpretation of the Army's regulation 27-10 that says the privatization of housing does not affect the ability to order searches? Is that what do we do with that?
I think to the extent that, again, if we're talking about Battle Park homes within the obvious control of a garrison commander, then that's certainly applicable. But we can't allow a regulation to overrule what is the plain language of MRE 315D1 and Chappelle.
Let's move on to the other two issues.
Yes, sir. Turning to the second issue. There are two reasons why MCO Regulation 190-11 does not and cannot apply to Porter Village. The first reason is Congress forbade the enforcement of a firearms regulation on private property. The second reason is the plain language of the regulation omits Porter Village, while this expressly including others. Now,
real quick, Captain.
Yes, sir.
But the 2011 NDAA prohibits tracking ownership of weapons on areas on land that is not owned or operated by DOD. So that's completely dependent on how we decide the first issue. But on the larger issue of this 190-11 applicability of the reg, what issues does it cover in this case, in your view? Is this central to the search authorization and the military judge's motions ruling? Does this affect anything other than the orders violation? Does it affect the assault? Does it affect the grenades? Does it affect the larcenies, in your view?
So directly, it affects the search and the fruits of the search, which is the firearms regulation, the firearms violations, the various 92 offenses. Now, when it comes to the assaults, the other offenses, two things to that. One, the unit never pursued. I think it's clear from the record my client has a history of assaults and issues that were never pursued by the command until this search came about. In terms of the direct correlation of evidence between the assaults and the fruits of the search, we'll concede that there is a break there, obviously, because many of these assaults that came about were before the search ever came about. Now, the impetus to bring all this about, as shown by the emails from the chain of command, was that they dredged up a lot of his old dealings and his old problems.
We're going to want to hear a lot about that. So if we can just make sure we focus on to what extent this regulation was the underlying basis for the search.
So to answer that, sir, the regulation obviously turns the issue of probable cause for us, which for us is the second prong of the good faith exception, and also, we also argue that if you don't find it that if we win on the first issue, we don't need to reach the second issue. Basically, we can go straight to good faith. But obviously, we still believe we win on the second prong anyway, sir.
Because if the commander doesn't have control over Porter Village, then we don't even need to look at whether there was probable cause in the
Exactly. We would just go straight to good faith. But even then, the first prong of good faith arguably turns on his authority to issue the authorization as well. So,
as defined under 315D, which says it's a commander with control or magistrate, right? Okay.
Yes, sir. So again, the first issue is the most important for us. It's our position that it is. The first issue turns the entire case. However, absent, if you find that the government met their burden and there was no error in the conclusions of law and the ruling, we can turn to the second issue. We still believe that this regulation does not apply to Porter Village. It cannot and did not apply to Porter Village.
So let's talk about the wording of the regulation.
Yes, sir.
And how much we're supposed to read outside the regulation to determine the meaning of the regulation. You would agree the regulation does not say that. So the regulation defines Fort Benning, and it says shall include. It doesn't say, is that a list, a demonstrative list of places that are included, or is that an exclusive list of places that are Fort Benning?
It appears to be, it's exclusive, Your Honor, because it reaches to another state. It discusses the MWR recreation destined area where the swamp area for ranger training occurs. The swamp phase of ranger school is. The government or the Army considered they considered reaching into other states when they thought about what this Fort Benning means. But
that would have been pretty easy for the writer to say, right? He said that Fort Benning means exclusively these four things.
They did not use the word exclusively, right. But they did use the word include. And that inclusion reaches out to Florida, from Georgia to Florida.
So under your reading, that means it can't include anything else?
Correct. I mean, if we're talking about, if we start at Fort Benning and we put a cone that reaches out to the state of Florida and Porter Village is not in there, I think Judge Sparks wrote in Mooney last year that to the inclusion of some is to the exclusion of others in Mooney. I think that holds true here.
So how do you reconcile that portion that you're citing there is in the summary of this regulation? In the first paragraph that talks about purpose, it says it applies to the weapons in any area within or under the jurisdiction of Fort Benning. So in your view, is that a conflict?
No. Our position is it isn't, because again, this MOA, which grants concurrent jurisdiction, just like in the suppression hearing, it accounts for the purchase, the original 1993 purchase alone of Porter Village. But it doesn't account for anything in 2000. I'm sorry, go ahead.
If military authorities have been supplementing law enforcement at Porter Village since the time of privatization, they've been doing that outside of the law, in your view?
Well, yes. I think that, and this kind of bleeds into the third issue a little bit, but I think the concerns military law enforcement expressed the day before the search was authorized speaks to your question. They told the chain of command, "Hey, we don't think a military magistrate could authorize this, but a civilian judge could get a search warrant for this." So I think that highlights the concern that they understand. Hey, even if this is okay, even if there's probable cause, we should not be spearheading this on Porter Village.
So, in your view, their hesitancy on the part of law enforcement after the search or when they were seeking the search authorization was a jurisdictional issue and not having to do with the substance of the basis for probable cause.
I think this court can easily infer that concern from that email that sent the day before.
Which concern? The jurisdictional concern?
The jurisdictional concern, which I know we supplementally cited the day before, and I apologize for the belated citation, but U.S. v. Baker, which is cited in Chappelle, is a 10th Circuit case where law enforcement expressed concerns about a search on Indian territory. Those concerns were noted in the affidavit. And the 10th Circuit said there was no good faith because of those concerns. And the same holds true here.
Counsel, what do we do if we think that you're right, that 190-11 didn't apply on Porter Village, but we also think that it was a close call and that it was reasonable for the commanders to believe that it did apply? For example, how does the exclusionary rule work in that regard? So essentially, it would be you're technically correct that
this regulation does not. Oh, so if putting that aside, let's put the firearms, the failure to register aside. Right. Let's just throw that out. There's not a lot left here to support the scope of the search. We'll acknowledge that yes, this tip came in the day. This tip about the grenades, one is 3 months old, but even putting that aside.
Yeah, okay, I'm sorry to interrupt you. My question is a little bit different. My question is saying, granted, a large part of the search authorization dealt with the firearms.
Yes, sir.
So let's assume that we think you're correct.
Okay.
That 190-11 did not apply on Porter Village, but we think it's a fairly close call, and that the commander could have reasonably believed that it did apply. Essentially a reasonable mistake of law.
It's not. I'll give you that it may be reasonable. Given on the record, it may be reasonable for the commanders to think that because they've been told by their trial counsel. You see their emails from the trial counsel saying there's probable cause. He failed to register. He's a dangerous guy. But the Supreme Court in Leon asked us to look at what the officers thought. The officers, they didn't believe in this search. And the day after the search was authorized by the commanders, who I acknowledge might.
But the belief of the officers is based on jurisdiction. And so Judge Ewing's question, I think, presumes you've lost the jurisdictional issue.
Okay.
Right. So we've determined the garrison commander can, in theory, with a properly promulgated regulation, require people at Porter Village to register firearms and therefore order searches for crimes if he didn't.
Yes, sir.
But we agree with, so that's gone. But we agree with you that perhaps by omission or mistake, they neglected to actually include Porter Village in the regulation that's applicable. So therefore, didn't violate the regulation as a matter of law. Tracking?
Yes, sir.
Okay. However, it's a really close call, meaning the regulation's a little ambiguous. A different judge, such as the trial judge, could have thought that it did. A garrison commander, acting as the magistrate authorizing the search, could have thought that it did. Mm-hmm. There are documents that say Porter Village is the housing area for Camp Merrill. Camp Merrill is specifically included in the regulation. Mm-hmm. But we conclude, we agree with you, it doesn't. So the garrison commander is wrong. There was, as a matter of law, no violation of the regulation, i.e. no crime. But it was a reasonable belief that there was a crime. What do we do with the search?
I think not I think, but the problem is the commander's belief. I think that the close call of this, it requires us to ignore the explicit concerns both the day before and the day after of law enforcement. It requires us to put that in the box and put it away.
I'm tended to not think that the police's subjective belief of what the law is will be controlling. I think it's going to be what our belief of the law is that will control the outcome of what the law is.
Roger, sir. But the concerns go beyond jurisdiction for law enforcement. It goes to the basis for probable cause in this tip as well, which has nothing to, and that's expressed the day after, sir.
But if their subjective belief in the quantum of evidence is a difference of opinion, are you saying that equates to bad faith?
Well, I see my time's expired.
May I answer the question?
Yes, sir. So, objectively, when we look objectively at what would a reasonably well-trained officer do, just as we in Baker, in Perkins, and in Thomas, here we have military police who are told by the garrison commander, "Go search here." They have to follow. They have to do the search. They have to conduct the search. A well-trained officer is not going to disobey an order, but if they have concerns about the search, they're going to tell them, "Well, look, we'll just create a subterfuge to go in there, or we'll just create another excuse to go in there. We'll do what you say." That's a subterfuge. So that's why the objective belief of a well-trained military police officer who's given an order to go search private property, they might have concerns and they may jump up and down, like in this case, and say, "We don't think this is legal. We think that there are real concerns. We have to do it anyway, but we'll just change the excuse." That, under Leon, doesn't make this a close call.
Okay.
Thank you, sir.
Carmen. Whenever you're ready.
Senior Judge Wolf, members of the court, may it please the court, I'm Captain Brian Jones. Captain Jeremy Watford and I represent the United States. I'll be addressing the assignments of error in turn. The Fort Benning garrison commander had legal authority to search the appellant's residence in Porter Village. And this court discussed the motion in my colleague's argument, what was written in the motion, but I think it's also relevant, pardon me, Your Honor, of what was conceded at trial. This court can look at the joint appendix at 139. Whereas military judges often do in motions to suppress, they first get the parties there and decide what facts do we agree on, what facts do we not agree on. The military judge asked the defense counsel, "You've read paragraph 9 of the government's motion. At this point, do you concur with paragraph 9 of the government's motion?" Defense counsel responds, quote, "Your Honor, the defense counsel concurs with paragraph 9 in the government's motion." I would then direct this court to joint appendix 334. Which shows paragraph 9 of the government's motion. The concluding sentence of that is, "Colonel Hilms, the garrison commander, was the appropriate authority to sign any search authorization issued for soldier residences in Porter Village." To the extent that that conflicts with anything in a defense counsel's written motion, I would note that the motion to suppress occurred 2 weeks after. So it appears that this issue was conceded by the defense counsel at the motion to suppress, but even if it wasn't, the government put in ample evidence for the military judge linking the control from the purchase of the land in 1993 to the Army's petition for concurrent legislative jurisdiction in 2006, to the governor's of Georgia's acceptance, or excuse me, ceding of concurrent legislative jurisdiction in 2009, all of which forms the control necessary under Military Rule of Evidence 315 Delta 1. And I would note that this court's review of a motion to suppress is for an abuse of discretion, reversing only if the facts are clearly erroneous or if the military judge's decision is influenced by an incorrect view of the law. It's when the facts are presented to the military judge or they're conceded by both parties, he can hardly be faulted for accepting that concession by the counsel.
Counsel, regarding the concept of control, I mean, my question goes to maybe a difference, maybe not, I don't know, between control on paper versus control in reality. And I was looking at Joint Appendix 175, which is the Camp Merrill Command Sergeant Major testifying at the suppression motion. And the Command Sergeant Major says, quote, "Just because you're the battalion commander and battalion command sergeant major Camp Merrill, which of course is, 3 hours away from Fort Benning or something like that. An additional duty that you get under our duties and responsibilities is installation sergeant major and installation commander, because nobody else is going to do it for you. Now, when I read that, I thought, well, these guys are seeing themselves as almost kind of out on an island. They're hours away from Fort Benning. So what am I to make of maybe is there a difference between control on paper versus control in reality?
I don't think geography in and of itself, severs any control, particularly in this case when you have the MOA that's signed by the governor of Georgia, but also the commanding general of Fort Benning at the time, and then you have this housing office that Villages of Benning that operates on the garrison at Fort Benning under the auspices. They're there to serve at the pleasure of the Fort Benning garrison commander.
Oh, are you sure about that?
Perhaps that's a miss. I'm a little too.
I think you're outside the record there.
A little too flippant there, Your Honor. Excuse me, but it does. They do operate on the Fort Benning garrison, and housing certainly is one of those traditional housing DES. These are all traditional responsibilities that fall under the control of a garrison commander.
I'm not really quibbling with any of that. My question is, I think I'm looking at the deed too, and it says that it's owned by the United States, but I guess my question goes really more to the reality of day-to-day control of Camp Merrill and Porter Village, potentially. And this, the way that the Sergeant Major is describing it sounds like maybe they're kind of out on their own. And is that meaningful? Maybe it's not meaningful. I don't know.
I'm not sure that it matters for the purpose of the military rule of evidence, particularly under an abuse of discretion standard. I would agree with you that this appears to be it's a housing community. Apparently, they all live there, and officers and enlisted alike. You have the testimony from Major Gibson as well. It says he lived there. Apparently, their security at Camp Merrill was a 4-person detail, but the record doesn't have a lot of other information other than talking about the geographical separation. But I would submit that, particularly under a motion of abuse of discretion standard, that doesn't negate the control in this case.
Let me rephrase Judge Ewing's question in a way that I think you'll find familiar. Is the determination of control, like who controls Porter Village, is that a question of fact? Meaning, if someone's actually day-to-day exercising control over it, they then, by doing so over some period of time, they now have search authority over it. Is it a question of law, or is it a custom of the service? What determines whether a commander controls the thing that is to be searched?
I suppose if it was somewhere in there, I could think of like a company commander, for example, has his own barracks. The company commander controls the barracks, controls the parking lot.
The barracks is easy. The parking lot's harder, right? Because people are assigned to the barracks in his company, and he controls what rooms they're in. The parking lot's kind of open parking usually, and so can he authorize the search of anyone's car that happens to be in the parking lot next to the barracks?
The company commander in that case, potentially he could, Your Honor. Yeah,
but the question's maybe, right?
Right.
And so if we're going to try to answer that question, and it's not a bad hypo you came up with. It was the one I was thinking of too.
Thank you, Your Honor.
What is it if he is regularly inspecting all the cars in that parking lot? Do we say, oh well, because it's a question of fact, and therefore he has control over the parking lot and he can authorize searches? Or is it a custom of the Army and our service in terms of what company commanders control while exercising command prerogative over their company and ensuring good order and discipline? Or is it a question of law in which somewhere we've defined you own this, someone else owns this, and there's like bright line rules?
I'm not aware of bright line rules, Your Honor. It would seem, I think in the context of housing, and going to the custom of the service, housing on a garrison, I would submit that's something that generally falls under the auspices of a garrison commander. That he would be, in this particular instance, when we have the MOA signed by, or potentially the commanding general of Fort Benning as well, but the housing responsibility, DES responsibilities, these are things that I'm sure there's Army regulations on these. I don't have them available to cite to the court, but I think that's something that, whether it's custom of the Army or just day-to-day practice, that's something that falls under the garrison commander's purview.
Ready to turn to what this regulation means?
If I might just add one more point, Your Honor, on 81, this discussion of the military private housing initiative, this privatization control of 2006, none of this was presented to the military judge. There are no findings of fact. There are no conclusions of law on this. And any bases for suppression not presented to the military judge at trial are waived under the CAF's decision in Robinson. And I would submit that that is applicable on the line of argument that principally surfaces in appellant's brief. And with that, Your Honor, I can turn to the second assignment of error.
Please do.
MCOE Regulation 190-11 applies to Porter Village and prohibits the possession of unregistered firearms in its quarters, but even if it does not, the garrison commander still had a substantial basis for concluding probable cause existed to search appellant's home. When interpreting a regulation, this court applies principles of statutory construction, meaning that it will apply the plain meaning of words and strictly construe punitive provisions, but not to an extent as to defeat a regulation's obvious purpose or intent. And in this case, looking at the Joint Appendix 298, and much of this was highlighted in my colleague's argument, but I would submit that the summary of the regulation is demonstrative, not exhaustive, but we can look to the actual purpose paragraph, 1-1 Bravo, which Judge Hagler, you already pointed to this, but it specifically says in any area within or under the jurisdiction of Fort Benning. I don't think it's impossible to read this provision of the purpose harmoniously with the summary and other provisions, but to the extent that this court elects to do that, I would, the canons of statutory construction would say not to read it to defeat it. I'm sorry.
How about the more specific mention of Battle Park Homes up in the applicability paragraph? You'd figure applicability would be something they would want to get right in 2014 when Porter Village was established back in 1993. At least we know we got ownership of the land at that point.
Yes, Your Honor.
Why would they choose not to include it, to put it in there?
I don't know, Your Honor. And as I said in my brief, this regulation, it's not a model of clarity. It could be written more clearly. But to the extent that this stuff, this summary, this applicability above the line conflicts with what's stated in the actual purpose paragraph in courts, and I didn't cite these in my brief. I apologize for that. But going back as far back as United States versus Baker, which is a Court of Military Appeals case from 1969, and then a Navy case, United States versus Hinojos from 2015, where that court, in addressing a regulation, looks specifically at the purpose paragraph of a regulation.
But I don't think that gets you that far. I'm sorry, please.
Yeah. Oh, I'm sorry. So, Captain Turner mentioned 6th Ranger Training Battalion down at Eglin Air Force Base. Let's say because 6th Ranger Training Battalion falls under Ranger Training Brigade at Fort Benning, let's say they wanted the commander of the garrison commander at Fort Benning to order a search authorization or charge someone for a violation of 190-11 down at Eglin Air Force Base. What about your whole approach would prevent them from doing that?
I don't know what the if there's would be a battle of jurisdiction down there at Eglin Air Force Base. I don't know if there's another commander who's responsible.
Regardless if there was a battle of jurisdiction, what would prevent the Fort Benning regulation from applying down there under your approach? Because it's not listed there. Are you saying anything that would fall under jurisdiction?
That with under the jurisdiction of Fort Benning, I mean that's what the regulation says, and it may. There may be circumstances that would lead to conclusions that would seem. I don't want to say absurd, but seem more odd or troubling than the facts of this particular case, where the place searched is actually a housing area where there's no dispute that it's under the current. Well, the government would submit there's no dispute that is under the concurrent legislation of the United States. But to the extent, but even if this regulation doesn't apply, this isn't the hill the government's going to die on today. The MCOE 190-11. I'd submit that it does apply, but even if it doesn't in this case, the garrison commander still had substantial basis upon which to make his probable cause determination.
But if he has substantial basis for something that's not even a violation, what's your authority for him authorizing a search?
I would submit that there's the Article 92 violations was just one part of his search authorization. I think the far more troubling allegation of which was the grenades in his house, the explosives device, which is something that the garrison commander noted in his search authorization. Yes, there was allegations about its staleness. This was a finding that the military judge clearly dealt with in his motion to suppress. It's afforded deference under that standard. But
I understand it came up quite frequently in the motion to suppress, but looking at what the garrison commander had and the information that was conveyed to him, are we limited to the four corners of the search authorization? Are we limited to the four corners of the information that was passed to him? Because we don't do affidavits in a similar way that a civilian jurisdiction would. What are we limited to in determining whether the garrison commander had a substantial basis?
I would submit that this court is not limited to the four corners of the document. That's the two cases that this court specified, Perkins and Thomas. This court can make reasonable inferences about the facts and circumstances and what the garrison commander considered and inferences he could have made about those. And his totality of the circumstances test, number one, a substantial basis determination is afforded deference by this court, and provided his analysis of the totality of the circumstances is not unreasonable, that deference should apply. In this case, we have perhaps more than in other cases. We have tons of email traffic, which is I admit is laborious to pour through, but I think it's what we can see here is that the command has rolled up all of this misconduct, including the weapons violations, including the grenades, and this was not an anonymous tip.
You also have differences of opinion in that email traffic, which, if we're to presume they all went to the garrison commander who did the search authorization, he lists the things that were observed there, and then possibly grenades. What do we take of his view that possibly grenades, in light of Perkins, that the mere possibility is not enough? I think in Perkins it says it's got to be an assessment. Probable cause requires an assessment more than an assessment that something is possible. What do we view of the garrison commander's assessment that it's only possibly grenades?
He lists possibly explosives, I think, and then in his list of things to be searched for, and I could flip to that quickly, Your Honor. I think he specifically lists. I don't have the search authorization right in front of me right now, but he lists firearms, grenades, explosives, other weapons. I think it's reasonable to infer that all that information was conveyed to him. We have email traffic going back and forth from the appellant's unit to the trial counsel, from the trial counsel to DES, and as this court talked about the jurisdiction, there may have been a jurisdictional question, but I would submit that issue was assuaged before the search authorization was signed.
I thought the reference to explosives was talking about the grenades in the search authorization itself.
I agree, Your Honor. I think
when he says possibly explosives, he's saying possibly grenades, right?
Yes, Your Honor. Grenades, and then it's possibly didn't want to limit that to only allowing them to, if they see other explosives there. I mean, if you say only grenades in there, maybe there would have been an issue with what they could have actually seized potentially. So,
I mean, in his authorization of what they could search for, he said explosives, but just in his assessment and laying out his basis for probable cause, he said possibly explosives, but he didn't use that possibly modifier for the firearms or anything else. So I was just curious about what your assessment was, if that is going to undermine a substantial basis.
I don't think it does, Your Honor. And what we do know is the information that the command was conveyed to by Sergeant Moody, who is deemed very reliable and should be deemed very reliable, and his testimony is at the motion to suppress there from 143 to 157, or the joint appendix 143 to 157, where he's essentially making, he's recalling appellant, apparently running around in an attack vest holding grenades, proudly displaying them to people, which this is all should be extremely concerning. And we know that information was conveyed to the garrison commander, including their command's assessment that he was a very reliable individual. So the word possibly, I don't think that negates the substantial basis determination in this case. I would submit that the grenades and explosives in his house would be reasonably be considered to be more troubling than unregistered personally owned firearms.
So I'd like to give you a hypothetical. Let's assume that we disagree with you and we say the regulation does not apply to Porter Village as a matter of law. But the garrison commander, so there is no crime of having an unregistered firearm on Porter Village in violation of an order.
Yes, Your Honor.
But there's, I think everyone in this room through 2 minutes of research could find a law that you violate when you have fragmentary grenades in your personal residence. So there are other laws that are out there that may have been violated. What do we do if a person authorizes a search for a crime that is not a crime, but there was a crime that they didn't authorize a search for?
So in this case, I think if they have I think this court can still apply good faith and uphold the fruits of the fruits of the search. In this case, we have the authorization was signed for the Article 92 stuff. I mean, the government submits, you can completely excise that. Fine, throw it away. There's still like you said, the grenades that he can authorize a search for, and once at their house, they had a legal basis to search and seize those items.
Are you aware of any cases in which a court was faced with the question of a search was authorized for something that was not a crime, but there was probable cause to find evidence for something that's not a crime, but there was probable cause, although it went unmentioned, for a different crime?
I mean, it sounds similar to the Sixth Circuit case that this court specified, where the affidavit contained allegations of I think it was drug trafficking, when actually the only evidence of a crime was possession of the contraband.
Church?
Forgive me, Your Honor, if this is the one that was just given to us yesterday, I think.
No, it's Church.
Church, yeah.
Aware of any other? That one's a little bit on point. Anything close? Anything else?
I'm not aware of any other case right now. I think there are cases, however, on, for example, I think that to the extent that this court finds the Chappell decision relevant at all, it should find it relevant for the fact that it still nevertheless applied good faith in that case to a determination, to a search where the court determined there wasn't any jurisdiction or control to authorize that search. The court, the CAF still upheld that search under good faith.
And no question, real quick, Captain Jones, no question that the search authorization requires specificity and the place to be searched and the items that could be seized, if there were items to be seized, but what you're looking for. How specific does the search authorization have to be in the basis for the search, what it is that makes it criminal? The defense has placed a lot of emphasis on the fact that 190-11 violation of the registration of firearms is the basis for the search. Your position is that actually it was the possession of the grenades that was the key item here. Is there a requirement that the search authorization or any equivalent warrant in civilian context be specific as to what the offense was that this is evidence of?
I'm not aware of that requirement, Your Honor. Now, the church opinion would seem to suggest that you can't just pile on stuff in an affidavit of violations of drug trafficking when there's no, drug trafficking or RICO offenses when there's no evidence actually that was presented to the authorizing official supporting that. But in this case, I mean, this court can look beyond the four corners of the document. It can consider, reasonably infer that all of this information concerning appellant, not just the 190-11 violations, but the grenades, the other stolen, the M4, the PEQ sites.
In church, they kind of justified that whether it was drugs for distribution or drug simple possession, that it was contraband either way, right? In this case, you've got weapons that are unregistered and you've got grenades. If the weapons were unregistered, if the lack of registration wasn't even a crime, they're not even contraband, right? So doesn't that...
Well, there were other weapons that were... Sergeant Mooney testified to a stolen M4 as well, others green-tipped ammunition that would indicate government ownership, PEQ sites that were commonly held in Sergeant Mooney's opinion could be government weapons. So there was 190-11, it was the grenades, it was the other observations of Sergeant Mooney, and I would submit that all of this was presented to the garrison commander.
So you're saying because of the stolen aim points, the laser aim points, and the green tip military issue ammunition are in the information that came up to him?
Yes, Your Honor.
Despite the fact that that's not in there.
And nor do I think it needs to be. Nor do I think the garrison commander needs to list all of that in his search authorization. We have evidence that was presented to him. And to the extent there was any concern between DES about jurisdiction or substantial basis, we have the trial counsel coming online immediately and saying, well, in our opinion, actually there is probable cause here. And that's very similar to the Perkins case, where the court looked to that. It said, the Perkins decision said, quote, the CO's probable cause determination would have seemed to be a ratification of what trial counsel had told law enforcement. And that's precisely what happened in this case. So to the extent law enforcement either had jurisdictional concerns or concerns about whether there was enough evidence to support a probable cause determination, you have the legal advisor saying, yes, there is, and the jurisdiction concern is assuaged. And that's the same legal advisor that talks to the garrison commander and the same legal advisor who's the POC.
But at some point, doesn't their concern or their skepticism about the basis for probable cause undermine a good faith search on their part?
It could, Your Honor, if there was any evidence of that in this case from a law enforcement officer who executed the search. What we do have is the unrebutted testimony of Special Agent I.L. at the Joint Appendix from 193 to 204, who was an agent on the ground who executed the search.
CID agent, right? Is his perspective any different from the MPI guys who were on the scene first? Whom the Deputy DES Director told, hey, this is not a search authorization. This is a protective or a safety sweep.
I'm not sure what that term even means. That's not a search the military does. So yeah, their inartful language or how they characterize this, particularly after the garrison commander had signed a document that says search authorization, I think is really of no moment. Particularly when these write-ups are 5 days after the 28th of March, they appear to be copied and pasted, But I do think the testimony, as Perkins noted, of the officer executing the search is relevant. And in this case, you have Special Agent I.L. who said, notwithstanding what this DES agent who was not there said, or to whom he communicated that, I don't know. But he understood that they were there to look for unregistered firearms and explosives. He understood the garrison commander's authority extended to Porter Village, fully read and understood the search authorization, had no questions about it. Nothing stood out about it, seemed reasonable, raised no red flags, had no doubts about its validity, and relied on it in good faith. And I would note, finally, that Special Agent I.L. participated in somewhere between 10 and 20 searches, so this is not his first day on the job.
Counsel, since we're talking about good faith now, I mean, there's some pending litigation actually was argued a couple weeks ago at CAF regarding this tension between the Carter case and the Hoffman case and those two lines of cases.
Yes, Your Honor.
Where do you think the law is in that regard? Actually, I think that was the Perkins case that's now at CAF that was arguing about that. So
that's correct.
Are we in? If we're in good faith, are we to apply Carter, or are we to apply Hoffman, which would be more of the plain reading of the
correct
rule? What is your view on the state of the law in that regard?
This court has said in previous opinions that it is applying Carter, and I believe that's the Davis opinion from the Army Court. But it said to the extent Carter and Hoffman have tension, we're going to apply Carter because Carter to us seems more in line with Supreme Court precedent in Leon. So my understanding is the Army Court applies Carter, but the government prevails either way, under Hoffman or Carter in this case.
I'd like your opinion as to whether the whole Hoffman-Perkins-Carter debate is moot, because I believe I'm correct in saying this case was arraigned after the effective date of MRE 311A3. Which was the codification of the Supreme Court's decision in Herring.
That could very well be, Your Honor.
And so what the Hoffman-Carter-Perkins cases all predate that, and it's a debate of whether we follow the Supreme Court case law or do we follow a rule promulgated by the president that's more defense-friendly, right? Because certainly the president can give an accused more rights than the Supreme Court says are the minimum.
Absolutely. And
so there's a tension, and then our superior court will figure it out. But this case was arraigned, I believe, after the president changed the rule to say that you only suppress evidence if the exclusion of the evidence results in an appreciable deterrence of future unlawful searches or seizures, and the benefits of such deterrence outweigh the costs to the justice system, which is Herring. And that seems to swallow the debate about what the good faith exception means and if it's applicable. So does it matter?
Well, I don't think it does in this case, Your Honor. The whole purpose of the exclusionary rule, a socially and drastically costly remedy, is to deter, as you just noted, is to deter law enforcement misconduct from recklessly violating constitutional rights. It's a windfall given to defendants in certain cases. But in this case, there's no law enforcement misconduct that warrants deterrence. I think, as the trial counsel noted in his argument at the motion to suppress, if we could go back in time and redo this, it's unclear what, if anything, would be different. We have a commander on the ground who's aware of this extremely troubling information, particularly about the grenades. He gives us other information. There's a litany of misconduct associated with this soldier. He calls his trial counsel. They work out, they discuss jurisdiction, they assess the evidence, they involve law enforcement. They find the right person who can authorize it, and they present the evidence to him and let that neutral and detached commander make a decision.
Yes, but you pointed out something that's a little different from this than the civilian context. You have the commander on the ground who is concerned about safety, who is also responsible for safety because he's a commander, and he's the one making the decision. Courts have shown some concern about treating a commander who is vested with prosecutorial authority in many respects and putting him on the same level as the neutral and detached magistrate. Does that weigh in one direction or the other here?
I don't think it weighs in either direction, Your Honor. As a threshold matter, the rules don't. It's provided you can be a neutral and detached magistrate or a neutral and detached commander. I don't think any commander's status as a neutral and detached was challenged in this case. In any event, the ultimate decision-making was done by a garrison commander who, while, yes, there may be some ad-con relationship between the garrison commander and appellant, it's not alleged that he was in appellant's direct chain of command in the Ranger Brigade. And certainly the commanders on the ground, they have an obligation under RCM 303 to look into any suspected misconduct. They did in this case, but they weren't the ones who authorized the search. They merely funneled that information through their trial counsel, which is exactly what we hope happens on the ground when commanders receive information like this. They hashed out the PC, they hashed out the jurisdiction, and they presented that to the garrison commander whose status was not attacked in this case. Pending any further questions of the court.
We have about a minute left. Do you want to sum up?
Yes, Your Honor. The garrison commander in this case had legal authority to issue searches in Porter Village. He also had a substantial basis for doing so, even if this court determines that MCOE 190-11 didn't apply to his conduct. And even if he didn't have probable cause, the good faith exception applies in this case. There is no law enforcement conduct that warrants deterrence. Thank you.
Thank you. Captain Turner.
There's about four points I hope to get through on rebuttal, Your Honor. First, to quickly shut down this concept of waiver. If we look at the bottom of J 311 and 312, the defense explicitly, when discussing the privatization in MRE 311 and 312, they actually discuss control. Arguably, this housing should be considered private, off-post housing over which no military authority may exercise control. Further, assuming arguendo that Porter Village housing is under military control, that control is tenuous at best. And then they go on to discuss Alaya and Chappelle. This issue is preserved. So, turning to the second point, Senior Judge Wolf, you asked about an interesting question about whether control over Porter Village is a question of law or a question of fact. It's a question of law in this case, given that just like in Chappelle, the government and the military judge, the sole basis for the basis to search was his responsibility. And the CAF in Chappelle, they say, the two arguments advanced by the government and by the military judge for the authority to search was law enforcement responsibility and running a housing office for this garrison commander in Chappelle. The CAF said the following: the sole authority relied on by the government both at trial and on appeal is the commander's responsibility to operate a housing referral office and directive to provide assistance to military personnel to provide housing, and that's at 413.
So what would you say if, because of a security threat, there's a security threat to Porter Village?
Yes, sir.
Right. So it's currently open to the public, but we're going to put gate guards, put a gate there, control access. Only residents and authorized visitors can enter. Can the garrison commander do that?
We don't have enough facts on the record to know if they do. We know that the Department of the Army has a business relationship with Porter Village, or not Porter Village. With Villages of Benning.
Would that answer the question? If they can control the entire community by preventing access to unauthorized persons, would that be? If we answer my hypo, yes. Have we also answered the question of whether the garrison commander controls Porter Village? Are they one and the same question?
Two responses to that. First, I think this court should look at J13 at US v. Bessinger. Again, that the federal government, the federal courts have already established that the federal government cannot exert control over these companies so as to avoid liability. So I would say, to answer that, no, they could not. The garrison commander could not say, "We're going to put a gate around Porter Village." Okay. I think that would plainly expose the government in light of Bessinger, which relies on Supreme Court precedent, to exert a matter of control that makes them now liable in cases where they've argued previously, like Brown versus Villages of Benning. We don't want it. Not only do we not control it, we don't want to control it because we don't want to be liable for torts that happen out there.
Now we're kind of dovetailing back to this initial question of who owns it. I mean, it's surprising to me that we're still it seems like an objectively true fact of who owns Porter Village. I mean, it's surprising to me that we're still arguing about that.
Federal. If we go, given that this wasn't the record at trial is light on this. Federal courts have established that, in quote, Villages of Benning owns and operates military housing at Fort Benning on behalf of and part of a real estate private venture with the Army. Again, and this is Brown versus Fort Benning on JA 13.
No, it does say owns and operates housing, right?
Right.
Could there be a distinction between the land and housing? If you own land in fee simple, can you not allow someone to build property on it, real property that is leasehold?
That may be true, but again, the challenge by the defense was that the commander's control was precluded by this privatization, which again, federal courts have established that the government has a legal interest in not controlling these companies and how they run the housing. Yes, sir.
You had 4 points.
Yes, sir. Sorry about that. Turning to
2 more to go.
Yes, sir. Sorry about that. The grenades. You asked the government a lot about putting aside the failure to register. What about the grenades alone? Let's look at JA 185. That's Major Calvin Gibson's testimony during the suppression hearing, and that's a record on 62. He's asked, and I'm on line 9, question, sir, earlier you said that when you initially spoke to legal, they said by itself, that's questionable. Is that correct? Answer, for just the fragmentary grenades? Question, okay, this was just the initial communication you had with legal, and this was a short response to you. Is that correct? Answer, that's correct. Again, and this lines up with the concerns expressed by law enforcement to the SJA the day after the search was authorized. They said, if we go on this grenade tip is stale and it's no good. You can thank you for the search authorization, but no thanks.
Last point.
Yes, sir. So the last point, you had asked, what if this was not based on probable cause at the time it was authorized, but we later find a reason to justify the search afterwards, or if we find evidence of a crime in the home?
No, my question was, we have evidence of 2 crimes. We authorize a search for one, not mentioning the second. Is the search invalid?
If you have evidence for 2 crimes in the home.
So evidence is presented to the garrison commander that there are fragmentary grenades, which violates all kinds of laws, and violates this reg. He authorizes a search based on it violates the reg. But we decide that's not a crime.
Yes, sir.
Is a search still valid even though he didn't, for a search for grenades, even though he didn't authorize it?
No. You have to.
That's all I needed.
Yes,
Your
sir.
time's up.
Thank you, sir.
All right, thank you both for your argument. We'll take the case under advisement, issue an opinion in due course.
All rise. The Honorable United States Army Court of Criminal Appeals now stands adjourned.
We'll be back in just 2 minutes. If you have to go, you have to go. We'll start the question and answer session. 2 points I missed earlier. We want to thank Dean Skank so much for inviting us down here. Lisa and I have worked together for many, many years. Thank you so very, very much. It's always a pleasure to come back. And there is a reception. After the question and answer session right here, it'll start at 1:30. I'm not so old, I don't remember what it's like to be a poor law student. No food, no break. Still come and eat.
It's like real court.
Yeah. They're coming right back. They should be In fact, these problems are being prevented from coming back by the exodus.
I think so.
David, let's get him in here.
All right. See you guys. Yeah.
They talk too much. I know. Terrible. Stay for that. What? Yeah, okay, got it.
A little bit more than normal, wasn't it? Right? There was a little bit tight.
Geographically.
I think I saw you as a drawing.
Right.
Okay, ladies and gentlemen, the court is now over. This is now a classroom, and so you can ask any questions that you want to anybody that you want to. Yes, ma'am. First question.
I am curious about any obstacles that you may have had to overcome in a very, very male-dominated, not just career, but also the realm in which you practice. If you could speak to that, and if you had to overcome imposter syndrome or anything like that.
Specifically about just being a woman in the JAG Corps.
Yeah.
I would say that just a few points on that. I understand. I mean, I have a lot of friends that obviously didn't join the military or the JAG Corps for that matter. So I understand what their experiences are on the civilian side. I can say that I have had a truly positive experience, and I really think that kind of comes back to what we do, and it's bigger than just being in the JAG Corps itself. Being a part of a values-based organization, and when you value each other, you value equality, leadership, those types of values, selfless service, integrity. I mean, I haven't had any, I guess, concerns or any issues that maybe some of my civilian friends talked about, or some of the articles I have read out there. And I really, truly trust the people that I serve with, and I think that makes a huge difference. I trust them not only because I know that they respect me, but I know that they're going to defend me. And so I would say that while I'm aware of things that are going on in different places, there is something truly different about the camaraderie that you have with the people that you serve, and the leaders that you serve with. And they really do truly set up a community of respect, and it's really empowering. And that is, I mean, I don't even really think about it in that respect. So I hope that answers your question.
Thank you so much.
Liz, you want to add on to that?
I've been in for 22 years, and what I found is that you're an attorney, and that folks just want good legal advice. So it's like going to the doctor. You want a good doctor. You don't really care if it's a male or a female. So that has always been my experience with commanders. I've never gotten any inkling from them whether they cared or they're obviously not female. They just wanted to test me to see how good of a lawyer was, how well I knew the issues, how confident I was, and whether I was going to stand up for what I believed in, or whether I was going to allow them to kind of push you around. Because you're a lawyer, a lot of times you have to tell them no. You have to frame it so that maybe what they want to do they can't do in that way, but you're trying to find a way they can accomplish what they want to. So, but I've never had any issues as far as being female. You do hear stories of women trying to break into combat roles where where the units are historically all male. I think that the military is changing over time. My husband's in the Navy. He's been on submarines, right after they changed and introduced women to the submarine duty, and also women on ships. So it's an evolution, and sometimes it takes the men in those organizations a little bit. But as far as lawyers, I think that it's just a non-issue for us.
And I would add that, as Dean Skank pointed out to me, it's a very poor representation of our court that we brought down here today. We're not all white males. A third of our judges are female, and they're not all white either. So it's just to let you know. But when we pick a case, it's those judges. That case has already been assigned to a panel of judges on a rotating random basis, and so we don't try to skewer anything to represent something that's not. This case was a Panel 4 case, and Judge Wolf is sitting here Panel 4, and that's just the way that is. So, but I would invite you to come out to the court anytime you want to and see us. Okay, next question. Yes, sir.
I'm curious if I'm someone that's interested in JAG, but maybe I'm only interested for 10 to 15 years. What experiences as a JAG Corps do you get that set you up for success in the civilian life as a lawyer?
Well, none of us are civilians. Right. So understand that I think we're probably not talking with authority when we answer that question. My experience is when I became a judge advocate, I was trying felony cases within 6 months. When I talk to peers from law school, and so I'm 14 years out of law school, so that would answer. I can tell you my experience, and you can say, well, how that would compare. So I've tried well north of 100 cases. I stopped counting at some point, and everything from multiple murders to the equivalent of parking tickets. So that's an experience that I think that you don't get unless you go work for a local DA making 25 grand a year and just go in the trenches for love of the job. You're not going to probably, you have to, and even if you did, you're going to have to work your way up and wait for the people to move before that happens. We routinely put counsel in courtrooms relatively quickly. That's at least on the crim side. They would know better. Is that still true, or is my experience dated?
That's true. I mean, I'll just reflect on myself personally. I've worked in a legal aid clinic. Most people on active duty, that's your first job after you work at a legal aid clinic on an active duty base. You do a larger base, so you're seeing routinely every single day. You're handling every single legal matter that's not criminal, and you're basically just handling every legal issue from EOD employees, family members, and soldiers. Every strike that's not criminal in nature. I've also been a special assistant U.S. attorney for an installation. Most people don't know that, but Army JAGs also can take on assignments for 18 months in the Department of Justice, prosecuting civilians who commit crimes on a military base. I did that. Prosecuted multiple felony cases, high-level stuff, Russian arms smugglers, guys impersonating soldiers, murder cases, all sorts of things, and that was in my first 3 years. When I went to Fort Bragg, I became a military prosecutor. I deployed to Iraq and worked in a strike cell, sort of being the legal referee for airstrikes in Iraq. Then I came back, I ran a legal office and represented sex assault victims, and then I came to this job. But apart from what I've done, you can also take in jobs in military contracting, which is highly lucrative on the outside. But apart from contracting, everything that we've done sets us up in terms of experience to step out and compete far greater than an associate at a firm who basically, doesn't get the in-court and in-person experience that I just described. Not even close.
And more than that, though, you're also a leader. So you're leading and advising and teaching and training other people, whether those people are soldiers, paralegals, civilian paraprofessionals, or each other. And that's an experience that is invaluable. I have been in charge of multidisciplinary teams in terms of working with different organizations on an installation on how to respond, investigate, and manage sexual assault cases. You might start out being a single action attorney, but eventually you're going to be running a team and learning how that works, and you're going to build off the skills of the leaders that you work for, but you're also going to learn from the leaders you advise. And those commanders have invaluable experience, and more than that, just life experience. And so it's not just the law at that point as a leader, it's also how to be one, and also like what is the moral and right thing to do. And those are the types of skills and experiences that I think are invaluable. And each of us here have been in the Army for about 8 years, and each of our jobs carries different responsibilities, but they increase as you stay in longer and longer. And those are just invaluable, and I think translate in a wide variety of ways to the civilian sector.
So I'll put a capstone on. You can look in the bios of everyone here and just see the different, I guess, vibrantly eclectic legal jobs everyone's had in numerous geographic, but it's not even like the areas, it's the types of law. If you look at my wife's firm bio, it says Andrea Cheek has been at the firm since 2010. She does patent law. That's the end of the bio. So ours, you can see all the different areas of law, and there's so many brilliant nuances and granular things we've learned and mastered in those different assignments. So sometimes the words on the page mean a little bit more than the words on the page. I hope that answers your question.
Thank you to everyone.
But if you're going to stay 16 years, you probably want to do them 4 more. 4 more. Right? I mean.
We'll tie you up and keep you the other 4. Next question. Next.
I got one.
Yes, sir.
Yes. How similar are the concepts in the civilian world when it comes to property law and contracts law to the UCMJ, and how the UCMJ approaches stuff like contracts and property law?
Well, UCMJ doesn't cover property law. So if there's a dispute about who owns something, we're not going to have a trial over it. That's going to be settled civilly. If you steal it.
Yeah, all of your contracts, all of your property law, everything else besides criminal is necessarily involves, federal. If it's administrative law, involves federal regulations. If it's operational law, it involves the law of armed conflict and DOD guidance that comes down through there. So the only thing that's exclusively military is military justice. And as you know, you've taken the class here, but it's remarkably similar. A lot of the names are different, and there are some key things having to do with the fact finder and process and procedure, but the rules of evidence and procedure are pretty darn similar. So.
Okay. One more. From our president.
I have a question about the power of the convening authority and how the system is maintaining balance when those powers are eroding, but defendants' rights are staying right where they are. How would you address that?
Can you first clarify what the convening authority is for those who do not know?
Yeah. Convening authority is usually, well, it's the person, by definition, the person who is entitled, who has the authority to send something to a court-martial, to send something to a trial, and the seriousness of that trial, usually depends in rank. So a junior officer, a lieutenant colonel, might send something to a summary court-martial that's only authorized to give 45 days confinement. A 2 or a 3-star general officer in charge of an installation may be able to send something to a general court-martial that can be empowered to, for a capital offense or life without parole or the most serious felonies. So the convening authority is the person actually in the military system who has prosecutorial discretion. They are not a judge advocate, they're not an attorney, but they're advised by a judge advocate at each of those levels I've just described. What the question refers to is that there's been a move to take the commander out of the military justice system, which would make it more mirror the civilian justice system, where prosecutors, attorneys have prosecutorial discretion, and that has a number of pros and cons. One of the upsides of it is it would be a decision that is essentially made by an attorney and similar to the civilian system. One of the downside is that would tend to make the commanders perhaps feel less responsible or place less emphasis on the outcome of things that deal with justice, protection of their soldiers' rights, and good order and discipline. So do we want to disincentivize commanders from thinking that that's important if they control all of the resources on an installation? You know, I think reasonable minds could differ on that, but there's certainly a lot that commanders have brought to the military justice system when I've advised commanders at every level from a captain up to a 3-star general. So, that was actually your question. But.
That answered?
Well, I guess my question is more, how are you maintaining balance when, you know, the Canadian Authority had powers for clemency, and now those powers are being taken away? Some article, like if an Article 120 is charged, it automatically goes to General Court Martial. I mean, how is the balance being maintained, especially in light that with panel selection, the convening authority selects the panel doesn't have to come to a unanimous verdict. So already, you know, service members are afforded fewer rights. And I mean, it's constitutional. Article 1, Congress can do that. But, you know, how is the balance being maintained?
So I'm not, it might not be, right? I think the system fluxes one side to the other. The UCMJ was created in the aftermath of World War II because there was wide-scale concern about how military justice was handled during the war. And they created a system that gave a lot of rights at various levels, to include commanders having pure clemency power. They created us, who also have the ability to set aside findings and sentences in a way that civilian appellate courts can't. And then over the next 70 years, initially, there was a lot of things that kind of civilianized it. We added judges. There were no trial judges until 1969. The rules of evidence didn't exist until 1980. Rules of procedure weren't introduced until 1984. And a lot of those things were addressed concerns that were to the benefit of the accused. Congress controls the system, right? They are empowered directly to pass laws governing the discipline of the Army and the Navy, and they are directing a little bit of a shift in the balance. So I wouldn't say it's necessarily going to be it's not going to maintain the same balance. It's not the same balance now that it was in 2010, but it also wasn't the same balance that it was in 1980 or 1968 or 1950. And that's the way Congress is creating the system, because they're getting pressure from various sides, and they adjust it accordingly.
It's kind of interesting too, the specific change to Article 60 that I think you're referring to, which is the convening authority's power. It's an interesting example of how a seemingly cabined change kind of can ripple throughout the UCMJ and have, actually just yesterday we had an oral argument down at the court that dealt with the interplay between the new Article 60 and a rule for court-martial that now maybe makes less sense in light of the new Article 60. So that sort of thing kind of has to percolate and play out. And we'll kind of see how that works. But it's an interesting, I don't know if it's called unintended consequences, but you change one piece of the completely interlinked puzzle, and you've got some ripple effects there.
So I think in 2014, Congress took away convening authority's clemency powers substantially. But effective 1 January, they were given some of it back to suspend sentences. So that's the system kind of, Congress went pretty far in 2014. Now they said we still need convening authorities to be able to suspend sentences sometimes. And they didn't give it all back, but they kind of gave a little bit of it back. So that's balance, I guess. We out of time, Dean? We are.
Yeah, we're out of time. Look forward to seeing you at the reception back there. Thanks a lot. You guys want to get the pictures?
2 days in a row, man. That's
I've done that as a litigant. That's a heavy lift. Another one I had 2 days in a row, and I begged out.
Well, 3 months ago, I had 2 arguments in caps.
Oh, in the same day?
No, I did pull back a photo. The whole day, yeah. 1 day.
Congratulations on Bodo. We'll see how cool that goes.
I don't care about that. firm, but I think there's going to be some strong language encouraging change.
We're going to do some pictures. So I usually pose and look all judicial. And feel free to gesticulate. Man with the camera, where would you like us?
Right there.
Okay, seated?
Yep.
All right.
Actually, why don't you stand? Because I don't think I'll be able to see you if you're. Yeah.
We'll do a time chase. No. Okay.
Yeah. Why don't you stand?
The pictures are done. What I would ask that you do is get the flag and get with Chief, you and Cody, get the robes from everybody and just hang them out here.
We're not trying to be mean, are we?
What do you think, we'll put the appellate counsel in front? Or back, we can
John,
put them in
how
the
are
back.
you?
I can
didn't
put them
have
in
a
the back
chance
with
to
the
say
students
hi.
in front.
I just happened to sit over there. You were accidentally going to sleep. I was out in the breast. I wasn't paying attention. This is no. Work on them right.
Yeah, we might have to put them all up because I'm not sure I'll be able to see them.
I can just roll.
Okay. If we can move that forward. So
As far as planning on staying, it's a heck of a podium.
Okay, that's gonna be a 5.
No, you're gonna be the first time I've gone
So
out.
yeah, do we want to?
Okay, so I can put the council and the students.
Yeah, I said I don't have to take them all. I've sent John Tate out to a couple. And I'm training Joe, so
These are students that have been selected.
someplace I don't want to be.
Right.
Or traveling gets, I get old. Traveling gets me down. I'd much rather stay at work.
Sorry.
You want to feed them in?
Well, you're.
Yeah. So do we want to do this group first?
This is with council.
Let's move. People on the bottom row. Let's move closer. And why don't we take one step this way? So we're.